Good morning or good afternoon, depending on where you are joining us from today. My name is Debbie Brenneman, and I'd like to welcome you to today's webinar. Thanks for joining us. I'm a partner in the Labor and Employment Practice Group. I reside in both the Cincinnati and the Dayton offices, and I'm joined today by my colleague Brittany Mallow from our Cleveland office. Today, Brittany and I will examine the potential impact of the FTC's proposed rule on non-competes, analyze some new state laws regarding non-competes, and outline actions employers can take to overhaul existing agreements, as well as implement trade secret protections to best protect their interests by alternative means. Before we begin to proactively address a question we often receive, today's webinar is being recorded and it will be sent to all registrants within approximately 2 business days, so you will receive that. Also, during today's presentation, please feel free to use the question panel at the upper right-hand corner of your screen. We will answer questions at the end of the webinar as time permits. But for now, let's begin with our content. So I will start by referring to the good old days of non-compete laws and policies. I've been litigating non-competes around the country for 20 plus years. And the traditional analysis of most states really was pretty simple. Non-compete agreements were valid and enforceable if the agreement was supported by consideration, contained restrictions no greater than necessary to protect the legitimate business interests of the employer, didn't pose an unreasonable hardship on the employee, and contained reasonable temporal and geographic limitations, or alternatively, some customer-based limitations. But those were the good old days. What we have seen in the recent years and at an increasing pace is non-compete agreements have been coming under increasing attack by local and by state legislatures, with many new laws that either forbid them or reduce their scope significantly. And I blame this, frankly, on Jimmy John's, because that was the case in New York a few years ago, where delivery drivers were signed up to non-compete agreements, and that started a big debate on non-competes. And it really was in the aftermath of a litigation over that we started seeing a lot of increasing legislation about non-competes and when they can be used.
And as Debbie said, there are a handful of states who either prohibit non-competes entirely or significantly constrain the ability to use them. Some of these states are California, North Dakota, Minnesota. Oklahoma has a law that says an employee shall be permitted to engage in the same business as the former employer or in a similar business as that conducted by the former employer, as long as the employee does not directly solicit the sale of goods, services, or a combination of goods and services established customers of the former employer. So that really just limits the opportunity for an employee to compete against the former employer. New York is next up to join in this group that essentially prohibits non-competes. On June 20th, the state legislature passed the bill, and it has been awaiting the governor's signature. Not quite sure when we can expect that, but we do expect her to sign that bill, which would add New York into the mix here. Additionally, in DC, this is not retroactive for existing agreements that are out there, but it does prohibit employers from imposing non-competes on most employees, especially for those that make less than $150,000 a year. Employees making over $150,000 a year, the DC law does allow non-competes with significant limitations, and if the employee is provided advance notice. And this applies both during and after the worker's employment. It applies to DC-based companies and employees who work in DC. Retaliation is prohibited. Like I said, requires advance notice and provides a private cause of action against an employer who violates the act, which allows financial penalties.
Yeah, that DC law is one of the ones that has me scratching my head most when it says you can't even use a non-compete while the employee is currently working for you. So that's that's really a bit nonsensical. And just another word on the New York law too. It has been, as Brittany said, on the governor's desk for a couple of months now. And there's some scuttlebutt that maybe she is seeking some amendments to the bill. The bill as written would completely ban non-competes with no exceptions. She certainly has been vocal about her disdain for non-competes for low-wage employees, but hasn't taken that broad of a stance. So there's some speculation that there's maybe some back and forth about amendments to that law. So we'll continue to follow that and issue an alert when we see what actually comes to pass in New York. So turning to what some of the other states have been doing with regard to restrictions, first one I want to talk about is Georgia. And until 2011, Georgia non-compete law was just governed by common law, and it was pretty hard to enforce non-competes there. In 2011, the legislature passed a statute that allowed non-competes if they served a legitimate business purpose, and it required them to be include limits in time, geographic area, and scope of protected activities, but it exempted customer-based non-solicitation provisions from these requirements. So an employer could have a customer-based restriction that didn't need to have those geographic limits or the same time limits. So an employee could be prohibited from reaching out to customers. But the law was silent with regard to employee-based non-solicitation provisions, that is, prohibiting the employee from reaching out to former coworkers to try to get them to join the employee at a new employer. In June of this year, the Court of Appeals addressed that, filled in the blanks there, and held that for an employee non-solicitation provision to be valid, it must have a territorial limit in order to comply with the Restrictive Covenants Act there. So any non-competes in Georgia that contain non-solicitations or employee-based need to comply with this new pronouncement from the Georgia Court of Appeals. Taking a look at some other recent legislation, and before we get into that, I will just note that this certainly is not a comprehensive list of states that have laws regarding non-competes. This is just touching on some of the more recent legislation. And the point is abundantly clear that it is no longer a case that with regard to non-competes, one and done is fine. Multi-state employers need to really make sure that they are looking at individual state requirements. We're also seeing an increased amount of litigation with regard to forum selection or venue selection provisions. So even if you attempt to have a choice of law provision that would be in the corporation's home state, it may be that that's preempted by laws of the state in which the employee resides or works. So it's really important to make sure that there is a review, a periodic review, preferably at least an annual review of non-compete agreements and take actions necessary to modify those if needed. But looking at some of the most recent laws in Oregon, the state set a time limit, 12-month maximum on non-competes, and also set that income threshold. But interestingly, Oregon also takes sort of the European garden leave approach in that if an employer wants a non-compete, they have to pay the employee to sit out. So it's pretty onerous in the state of Oregon. Nevada has a new law prohibiting non-competes for hourly employees and limiting the ability to restrict a former employee from providing services to the employer's customers or clients. So some limits on that ability as well. Turning to some other states, what we've seen most with regard to states is really focusing in on prohibiting these types of agreements with lower wage employees, and what's defined as low wage varies certainly from state to state. In Illinois, the new law there sets a $75,000 salary threshold for non-competes. It has to be supported by 2 years of employment or other consideration, some kind of payment or a promotion, something like that. There is a salary threshold for non-solicitation provisions as well that's a bit lower, and the Illinois law automatically bumps those salary thresholds up every couple of years for a period of time. So that's something that will be in flux for a while as well. Maryland has a law that sets a pretty low salary threshold. Virginia has a salary threshold law as well, And it's kind of complicated to figure out. It's defined as those whose average weekly earnings are less than the average weekly wage of Virginia. So it requires some type of calculation with regard to that. So this is just, again, some of the most recent legislation. We're seeing more and more laws. In fact, Minnesota is another one on this list that passed a law effective July 1st, I believe, that was on highlighted on Brittany's list of those prohibiting non-competes. It is not retroactive, but it is on the books as well, and certainly reminds us that these things are changing all the time. Every month or so, we are seeing more changes in state legislation. And also seeing some action on the federal front, which we'll start getting to with Brittany here.
Yeah, so it's been a big year for the NLRB, specifically the General Counsel, Jennifer Abruzzo. Before the May 30th memo that she issued back in February, there was a decision, McLaurin-Macomb decision, which essentially targeted severance agreements and specifically confidentiality and disparagement clauses within those. There was another memo she issued thereafter, which discussed the effects of those clauses limiting employee rights under their Section 7 rights under the NLRA. And along the same line, she issued this May 30th memo, which essentially it does announce that, in her view, the pro-offer, maintenance, and enforcement of non-compete provisions violate Sections 8A1 of the NLRA, except in very limited circumstances. She calls on the NLRB regional offices to bring cases of arguably unlawful non-compete agreements, as well as special circumstances, to the NLRB's Division of Advice. And recently, on September 1st, the Cincinnati region of the NLRB actually issued a consolidated complaint against an employer in part due to unlawful confidentiality, non-disparagement, non-compete, non-solicitation, and they took special offense to the training repayment provisions there, where that employer was essentially saying that if someone left, they owed upwards of $50,000 to $60,000 repayment for training. I took a look at those specific provisions that are listed out in that complaint, and it's pretty aggressive and egregious language, but it does really remind us of kind of where things are going. And this is one of the most recent examples of the regional offices actually taking a closer look and gathering these examples and issuing this complaint, which we think is just kind of setting the tone to continue on in other regions around the country. The GC also directed in her memo the regional offices to seek whole remedies for employees who can demonstrate that they lost opportunities for other employment due to the overbroad non-compete provisions. And this is touched on in that consolidated complaint out of Cincinnati that I mentioned. So which employee rights does she reference? Virtually all employees are covered under the NLRA. This includes both union and non-union workforces. Section 8A1 of the NLRA states that an employer cannot interfere with, restrain, or coerce employees in the exercise of the rights guaranteed in Section 7. And because she argues that non-compete agreements interfere with Section 7 rights, they therefore violate Section 8A1 due to a technical reading of that statute. Section 7 of the NLRA generally affords employees the right to unionize, collectively bargain, and engage in other concerted activity for the mutual aid and protection. For example, employees discussing unsafe working conditions, discrimination, or low pay would be considered protected concerted activity. Also, another thing that was touched on in the consolidated complaint out of Cincinnati was that the employer had told employees broadly that they weren't unable to discuss any employment terms. So that's another example here of that concerted activity that the General Counsel and the NLRB are trying to protect. The General Counsel detailed specific types of protected activity under Section 7 that she feels are chilled by non-compete agreements. One of those is carrying out threats to resign or resigning to achieve better working conditions. She stated she also believes that threatening to resign falls under Section 7 as well. She also references seeking or accepting employment with a different local company to obtain improved working conditions as another employee right. The third one is recruiting coworkers to work for a local competitor as part of a broader course of protected concerted activity. And finally, seeking employment for the purpose of engaging in protected activity, such as union organizing. The memo goes on to identify reasons why non-competes can be seen to chill Section 7 rights. The first thing that she mentions is the threats to resign become futile given the employee's lack of access to employment opportunities. Also, employees' fear of retaliatory legal action. It makes job changes more difficult, and it limits employees from the kind of mobility required to engage in some of the activities such as union organizing, which may involve obtaining work from multiple employers in a specific trade or geographic region. So basically, she is saying that all of these restrictions that are found in typical non-compete provisions make it very difficult for employees to leave. So by having the non-compete, you're essentially chilling their rights and they can't actually act on those. So therefore, these provisions should be deemed unlawful. So the question becomes, are non-compete provisions ever lawful? The memo indicates that non-compete restrictions could be lawful in some cases if they are, quote, narrowly tailored to address special circumstances justifying the infringement on employee rights. So what does that mean? What is not a special circumstance? The GC explained that a desire to avoid competition from a former employee and business interests in retaining employees or protecting special investments in training employees would unlikely ever constitute special circumstances. A non-compete is unlikely to be reasonable when overbroad provisions impact non-high wage employees who do not know trade secrets or similar information. So this leads into the next slide, which is what is a special circumstance. So as the GC indicated, if you're restricting only individuals' managerial or ownership interests in a competing business or true independent contractor relationships, that non-compete provision could be deemed lawful. Additionally, if you're restraining employees from misappropriating trade secret information and customer relationships, it may constitute a special circumstance, which would deem the non-compete provision lawful. So what kind of authority does the NLRB GC memo really have? So the memo is not binding, but it does represent the latest initiative to limit non-compete restrictions in both unionized and non-unionized environments. And as we've already touched on, states across the country have started to pass their own laws, which are essentially banning or making it very difficult to offer non-compete provisions which would be deemed lawful. The memo instructs regional offices to deem most non-compete provisions unlawful. Employers could be in hot water when facing an unfair labor practice charge.
And while the NLRB has been on the prowl on non-compete, so has the Federal Trade Commission. It has firmly entered the fray with regard to non-competes and has gone about this by two separate avenues of attack. First of all, the FTC has been out there, if we go to the next slide, please, has been out there pursuing individual litigation against various companies mounting a challenge to their non-compete agreements. There have been about 4 of these kinds of enforcement actions this year. And interestingly, the agency has been targeting the glass manufacturing industry. So they've really gone after it. And in some of the opinions have suggested that they believe that the glass industry is artificially small and that there's a lack of mobility. There are barriers to entering the marketplace because all the good employees are gobbled up by just a handful of employers. So they've really been going after those kinds of companies. In one of the latest resolutions, it was with Anchor Glass challenging their non-competes. And the settlement agreements that they've been able to get are very broad. So this particular settlement agreement prohibits the company from entering into non-compete agreements with employees, and that's any employees, including top-level employees. Additionally, the agreement specifically requires Anchor to notify current employees that its non-competes don't hold water, they're not valid, and provide some other types of postings and notifications as well. So this kind of enforcement action really signals the FTC's focus on non-compete agreements, at least during the current administration. If things were to change in the next election, I expect that we'll see a change in the FTC's appetite for non-competes as well, but we are firmly in this territory right now. The other thing that the FTC has done, as I'm sure most of you have heard, is issued a proposed rule with regard to non-competes. And I want to spend a chunk of time really talking about this. So when President Biden was on the campaign trail, one of the things he talked about was non-compete agreements, and again, the fact that he disfavored non-compete agreements. And it was not long after he took office when he suggested to the FTC that it ought to consider some proposed rulemaking. But that kind of sat out there. Initially, we all sat up and took notice and thought, oh, what are they going to do? And then nothing was done, nothing was done, nothing was done. And then more than a year later, on January 5th of this year, the FTC came out with its proposed rule on non-competes. Given what we saw with, what we've been seeing with state legislation and really the focus on these salary thresholds, a lot of us, who dwell in the non-compete landscape, including me, thought that it would look something like that it would be based upon certain salaries or perhaps positions, something like that, if they were to enter the fray. But we were all surprised on January 5th when the FTC came out with a rule that just would completely ban non-competes for all employees, all contractors, anybody providing services to a company for money. So that was kind of a shock. What the FTC has said in its motivation is that it believes that non-competes inflict on workers because it stifles their compensation and their mobility. If basically if an employer has somebody signed up to a non-compete, they know they can't go somewhere else. They're kind of locked in. They may not have as much negotiating room, in terms of salary, et cetera. And also this notion that we've seen in some of the enforcement actions that, these non-competes keep a lock hold on good employees, and that makes it really hard for new businesses to kind of break into the market. And when I give these presentations, I have to always apologize for my role in the FTC's action here, because when I was reading the 100 and some page guidance or publication that came along with a proposed rule, I saw that in footnote 29, it cited as one of the reasons why non-compete should be banned a case in which I successfully enforced a nationwide non-compete against a top-level executive a few years ago. So sorry to you all for my role in that. And we'll talk about these kinds of agreements later, but it really was, it was a case that we argued at that time. If ever there was a reason for a non-compete, that case was the reason. This guy was one of the top 4 executives in the company, had access to every piece of information about all aspects of the business throughout the country, and was seeking to go to work for a competitor in exactly the same role, and would inevitably use, all the variety of information that he had gained with our client. And the court agreed with us and enforced that. So those are the kinds of cases where there really is a need for a non-compete, but yet gained the criticism of the FTC in looking at whether non-compete should exist. Diving a little more deeply into the proposed rule, it's not just a ban, it's a retroactive ban as it's currently written. So every agreement that currently exists with every employer would go out the window. It would not matter what state law said. If state law says, hey, you can have non-competes, this would override that. Employers under the rule as it's written would have to go to its employee base and tell them, provide notice that these agreements are null and void, and that they're able to go out there and freely compete. There are a couple of things that the proposed rule does not include. Going to the next screen, confidentiality agreements would still survive this proposed rule. So would non-solicitation agreements, but they can't be so overbroad, according to the FTC, that they would be de facto non-competes. What do I mean by that? And the FTC hasn't completely spelled that out, but consider a situation with a non-solicitation agreement for a sales representative, for instance, that says you can't solicit any of the company's customers for 18 months. If it's not tied to a particular territory or to customers that employee dealt with, and that's the only industry that the employee has been in, then I suspect that would be something that the FTC would consider to be a de facto non-compete. Of course, I think that there would be years of litigation in all the jurisdictions trying to hammer out, what turns something into a de facto non-compete and what does not. But at least, the rule contemplates that there would be a continued ability to use confidentiality agreements and narrowly tailored non-solicitation agreements as well. So under the rule itself, there was an original framework that we thought this was going to come out quickly, and we thought it was going to end pretty quickly with some kind of rule. So there's a public comment period that originally ended in March of this year. Because there were so many comments coming in, that was extended by a month to April 19th. But it appears that there's been a very, very heated debate on both sides. The commentary suggests that the comments that have come in have been pretty evenly split between those favoring the use of non-competes and those criticizing non-competes. And we really, I thought when this rule came out so in such a broad form that really the FTC would give pretty short shrift to the public comments, but they've hired extra employees to sort through those comments. It appears that they are substantively considering them. And there's been news that the vote by the FTC has now been delayed until April of 2024. No commitment on that. I suppose that could change any time, but there's a suggestion that it will be early next year before we see what a final rule might look like. Now, it's important to note that when the FTC announced the proposed rule, in its commentary, it did specifically talk about alternatives that it had considered, and talked about the types of public comments that it was seeking. It specifically stated that it wanted input on whether there should be exemptions for certain categories of employees, C-suite employees, officers and directors, key employees, what that might look like. It also wanted input on whether it would work to have a presumption that agreements are unlawful, but that be a rebuttable presumption. And it also considered what I consider to be a pretty laughable alternative, which was well, hey, why don't we just have employers submit their agreements to us, and we, in our swift action, will decide which ones look like they're enforceable and which ones aren't. So I really, really hope that they don't go with that alternative, because I don't think we'll ever get an answer to anything in that route. With regard to these categorical, these possible exemptions, the categorical exemption, the FTC did observe in its commentary these state trends that create different standards based upon workers' job function or their income. And the FTC said it considered that, but preliminarily concluded that it would prefer a uniform rule because it said it thought it would create more certainty for workers. but again, asked for input on that possible alternative as well. With regard to the rebuttable presumption alternative, it recognized that a rebuttable presumption has some advantages over a categorical ban, where a non-compete clause does not raise competitive concerns, where it's really focusing on information that's shared or limiting in some way. But once again said, look, we've looked at it, but right now we just think that, again, a uniform rule is better because it will eliminate confusion in the marketplace. In terms of when this will happen, once the FTC actually takes it on, it will, when a final rule is announced, it will be pretty swift. The rule will be announced, it will be published in the Federal Register, and then it will take effect 60 days after publication in the Federal Register. There will be a 180-day, what they call implementation period, so kind of a grace period. So you would have 180 days to notify employees that they no longer have non-competes, to take all the steps necessary to change those, to maybe implement new agreements that would be more along the line of non-solicitation provisions, or if there are some exceptions or the rule changes, to create agreements that comply with what the FTC says is permissible on a go-forward basis. Now, this is not, it's certainly not a done deal. There have been multiple groups that have announced plans to challenge any rule in the courts. And those include the United States Chamber of Commerce and some other big organizations. So I think as soon as something is announced, there will be litigation. It's possible that there will be an injunction put in place. So I think we're going to face a great deal of upheaval and uncertainty once a rule does come down the pike. And these groups seem to have, I think, some pretty substantial challenges to the FTC's proposed rulemaking that they can take to court. Among those are the argument that the commission, that this just exceeds their authority, that they don't have the authority to engage in unfair methods of competition rulemaking, which this would be. Another argument is that there is not clear congressional authorization to ban non-competes, as would be required under the major questions doctrine. And also an argument that the rule would violate the legislative non-delegation doctrine in Article 1 of the Constitution. So there are going to be a lot of very meaty challenges, and I think challenges that will take a while to play out in the court system as we see once we see this come to pass. But there are some things that we can do now, and I will turn it back to Brittany to start talking about that.
Yeah, so given the pending FTC rule, the NLRB memo, and where states have been headed over the years, the question for employers is, what do we do now? Well, the first two things you can do would be to review all existing agreements that you have, and this can include, in addition to non-competes, also what your employee handbook says and what severance agreements say. And you want to really consider and prepare alternative agreement language to have ready should any of these, the final rule, for instance, go into effect, and you'll really be miles ahead of the rest of the group if you have something ready to go rather than scrambling around once the FTC rule does come out. And you don't want to, as Debbie said, though, there's likely going to be an injunction and significant legal challenges to the rule, but you don't really want to wait around and take that risk. So at least re-examining all of your agreements now will help put you ahead. So whenever you're taking a look at your confidentiality agreements, there's three things that you can really narrow in on. The first is you want to define your confidential information carefully. Make sure that that definition isn't overly broad. Those overly broad provisions have been deemed unlawful. You want to make sure that you state the reason for disclosure to employees. So a lot of the language we like to see is, after you define what the confidential information is, you're going to go into why that confidential information has been disclosed to an employee, and then reiterate the prohibition on use, dissemination, copying, theft, and disclosure. So we believe that if you focus on these 3 pillars when reevaluating your confidentiality agreements, you should be okay moving forward under the FTC's proposed rule and other pending state legislation. Whenever you're taking another look at your non-solicitation agreements, a couple of things you can do as well. You want to identify the importance of relationships and of employees' involvement in cultivation of those relationships. Also, you want to avoid overly broad prohibitions, something that would say the company's customers and prospective customers broadly is not going to be enough. At the very least, you should define that to be those in which that employee has had direct contact with leading up to their termination of employment, and even better than that, limit it up to the prior 6 months or year. The less broad you can make that and you can really narrow the focus of it, the more likely it is to be upheld. You also want to consider the necessary geographic restrictions. A lot of things with states that have come out with bans or essential bans on non-competes, one of the things they've focused on is the geographic restrictions piece. So you really want to think about how restrictive you can be to still fulfill the needs of the business. If 50 miles does it, if 10 miles does it, if 5 miles does it, then that's what you want to consider and really take a look at as far as revising your agreements so that you're not overly restrictive.
And Brittany, if I could jump in on that last point for a moment, going back to what I said earlier about your agreement should not be one and done. That's another key point with regard to geographic restrictions as well, because you need to be taking a real-time look if you're using a geographic restriction on what that employee is responsible for. So it's easy when it's a sales rep, right? And you can say this is their territory, or if they're selling nationwide, then that's their territory. But when you go up the ladder and you have maybe scientific people, or certainly you have high-level managers, C-suite folks who do have responsibilities nationally or internationally, then that would be the appropriate scope of their restriction, and those still are enforceable, but you just want to make sure that it comports with what that employee's duties are as well. So that's, again, you should not just have one agreement that you use with everybody in the organization who has a non-compete. You need to make sure it's appropriately tailored to the position as well.
All right, and so broadly in reviewing all of the agreements, you want to make sure that you include an attorney's fees provision, include a notification provision, and include a provision that extends the restrictive period in the event of a violation. So those are 3 things when you're looking at any of these agreements that you can implement. Another thing employers should be doing now is to audit trade secret policies and protection practices to ensure that everything is properly defined and the restrictions are proper in such a way that the language will still restrict the trade secrets without being overly restrictive and something that would violate either under the FTC's proposed rule, any applicable state legislation, or following the GC of the NLRB's guidance. You really just want to take a look at these because the trade secrets and proprietary information is arguably the most important piece that employers are trying to protect against by having a non-compete to begin with. So you really want to focus on those. And Debbie, do you want to talk some more about the trade secret precautions?
I will, thank you. Sorry, I didn't unmute myself. I'm going to talk about trade secret precautions in 1 second, but backing up, Brittany, to something that you mentioned earlier on some provisions that you should make sure are included in all of your agreements. The attorney's fee provision that Brittany mentioned. Will every court enforce that? No, they might not, but it is great leverage to have as a bargaining tool. And also if you're in a situation where you're sending out a cease and desist letter or a, hey, let me remind you of your obligations kind of letter, and you have an attorney's fee provision, that can pose a significant threat to an employee who might be contemplating violating, the agreement. It's also important, make sure that language is good. So many times a client shows me an agreement that they have, and in their non-compete, it will read that the prevailing party is entitled to attorney's fees. So don't put that in there. Don't put yourself on the hook. You just want to say that in the event of an enforcement action, the employee will pay the company's reasonable attorney's fees. Brittany also mentioned a notification provision, and I really like to use these that requires the employee for the duration of the restricted period to let the employer know every new employer during that period of time. Likely the employee will not do that, right? They're just going to go off, and especially if they're violating the agreement, they're not going to notify you or the new employer. But it's important to have it in there because oftentimes, I'm sure Brittany would agree, when you're in these enforcement actions, the bad actor issue is really what pushes courts oftentimes to go ahead and enforce. So if an employee is sneaking around, if they've taken information, like we'll talk about in a minute, if they've failed to provide the notice that they're supposed to, it makes it look like they're sneaking around, then that makes them look like a bad actor and really helps tip the scales when the court's considering whether to enforce these agreements or not. So just a couple of back notes there. Going on to this, the notion of a renewed importance of trade secrets, the FTC, in fact, in its commentary to the proposed rule, did suggest that, hey, we understand that employers have legitimate business interests to protect, but geez, folks, you guys have the Defend Trade Secrets Act, and you can use those avenues to to protect your interests through trade secrets types of avenues. I think that's short-sighted, and I'll talk more about that in a minute. But it is glaringly clear that non-solicitation agreements, which would be permitted by the current version of the rule, are all well and good for employees that interface with customers and have those kinds of relationships, but it doesn't do anything to protect many key employees. It would not, you're not going to go after, somebody who is leaving as a president of the company or a key manager, who may not have any customer contact, but they know everything about the business and could just torch the company if they go to work for a competitor. Non-solicitation provisions don't do anything. So if the FTC's rule goes forward as it is, or we see an uptick of what the NLRB is doing, it really does warrant renewed focus on trade secret precautions. And the only time to do that is before your trade secrets go out the door with a former employee. So speaking a minute about the Defend Trade Secrets Act, which was passed a few years ago, it is a very, very valuable tool for employers. And I did a little happy dance when this statute went into place because it creates a federal right of action. So first of all, then that gives you the opportunity to go right into federal court, which may often be preferable to many state and local courts that may not have sufficient expertise in this areas, or may be disfavored by state court judges. This gives a path right into federal court and a great option. It also allows employers to seek recovery of punitive damages and attorney's fees. Of course, they have to provide notification in their agreements that employees are immune from liability under the Act if they're engaging in whistleblower purposes, et cetera. But this is a very, very valuable tool. But again, it has to really, you have to really be protecting your trade secrets to be able to utilize it. So taking a look really at trade secrets best practices for a minute, and we'll talk through these. Trade secrets on it, misappropriation of trade secrets on its own can be a way to enjoin a former employee from working for a new employer. It may be through actual misappropriation. In those states that recognize the inevitable disclosure doctrine, it may be through that. And I have on multiple occasions created essentially non-competes through the court when my client did not have a non-compete agreement in place, but employees misappropriated trade secrets. I had a case several years ago where the company actually did not have non-compete agreements, and the client came and said, geez, we've got this very senior employee who's responsible for our biggest account on a global basis, and he's going to work for a competitor in exactly the same role, working with exactly the same client. I don't think we can do anything because we don't have non-competes. It's not common in the industry. And I said, well, let's take a look at his computer and see, if maybe he has gotten into the trade secrets. And the client was adamant that, no, you're not going to find anything because, we have these strict policies. We don't allow the use of electronic storage devices or anything like that. So there's not going to be anything. And I said, let's just take a look. The client conceded, and we found that that he in fact used not only a portable electronic storage device, but 17 different portable electronic storage devices in the weeks preceding his resignation, and had downloaded onto them a vast variety of trade secret information. And through that, we were able to first of all, get an injunction and then craft an agreement whereby he agreed to stay away, to refrain from working for any competitor anywhere in the world for 2 years. So obviously that's an egregious situation that he found himself in, and a great result. But it is possible to utilize trade secret theories to enjoin folks from going to work for competitors. But the only way to set those cases up is before your people leave. So it is really important, especially at this juncture with the FTC's actions and the NLRB's actions, to really make sure that you are engaging in best practices with regard to your trade secrets. Some of those include setting protocols for key employee departures. So that's, defining who are your key employees, who are the people, if they leave these positions, that they could create a tremendous risk to us if they went to work for a competitor. So identify those folks and make sure that when they are departing, that you follow a protocol, that you remind that employee of his or her obligations to the company, whether there are agreements in place. At least there should be confidentiality agreements, if not non-solicitation, and hopefully into the future some type of non-compete, but remind them of those obligations. Consider providing notice to the new employer. Even if they're permitted to go to work for the new employer, it would be wise to say, hey, while they may be permitted to work for you, they hold a vast amount of trade secret information belonging to us. We are going to be closely monitoring the situation, and we will take action against you and the former employee should we suspect that there's any misappropriation or use of our trade secret information. So that puts the employer on notice too. Maybe they back away from the employee. Hopefully at least they put some safeguards in place. And if they don't do either of those things and the employee starts willy-nilly using the information, then you've put them on notice, and now they can be a defendant in that lawsuit as well. I urge that with regard to key employees, that employers do conduct an email review upon their departure. The IT department can do that, pull emails from the last 30 or 60 days. And I'm surprised, continue to be surprised by the fact that employees still rely on company emails to do a lot of inappropriate things that will help in an enforcement case, whether that's emailing themselves documents, emailing themselves files. You have emails with their plane tickets for their interviews with the new employer. You've always got, there's always some nuggets in there that will help shed light on some things, and that can be good, good things to use in an enforcement action. I strongly, strongly recommend that when key employees depart, that you either can have a forensic review performed on the hard drive of the computer, or at least that the hard drive or a mirror image of that hard drive is preserved. There are all variety of circumstances where employees suggest that, gosh, they're going to go back to school, or they're going to retire, or they're going to go do, they don't know what they're going to do. And it comes to light, a few weeks later that in fact they had planned all along to go to work for a competitor. too many companies just wipe the computers and put them back into circulation, and that eliminates any ability to see what the employee may have been doing prior to departure. If you preserve that hard drive, you can see what files were accessed, what things were deleted, what electronic storage devices may have been used, get the serial numbers of those devices, really create an evidentiary trail and a path of information on what you need to retrieve that's been taken from you. So it's very important. Also very important that this is not a task that a manager or a supervisor or even an IT department do, because if you have one keystroke on that computer, you're going to start changing the metadata that's on it. So last access dates of documents could be changed. And those are, that's a very important data to have. So if you're going to be implementing or you follow this kind of practice, make sure that you spend a little bit of money to have a third party create that forensic image and conduct an appropriate review. With regard to your existing employees, there are also a couple of other best practices that I recommend. One is consider establishing some kind of monitoring policies. Again, there are third parties that can provide the software and help out with this, but there are a few different types of monitoring that can take place. One type of monitoring is if an employee accesses a certain number of documents within a defined time period. So often what you see is employees, they're on their way out and they start dipping into every good document that they think might give them a leg up in their new employment. So if you see a certain number of documents that's unusual, a red flag would go up, the IT department would be notified, you can look into it. Another type of monitoring would be key document monitoring, so that certain strategic documents, your business plan, things that are you absolutely would not want going out the door, that every time anybody accesses that document, again, a red flag goes up, and then you can evaluate, is that an appropriate access? Do they have a reason to be accessing this right now, or should we be asking questions? Another thing to do, particularly because we are now in this hybrid work environment for many employers, thanks to COVID, is make sure that you review and update your remote work policies to make sure that you are protecting your trade secret information. One of the first hurdles in a trade secret action is establishing that you have trade secrets and that you're taking reasonable steps to protect the secrecy of that information. There have been cases with remote work practices where an employer's failure to utilize confidentiality procedures has invalidated the trade secret status of information. There was a case pretty early on in COVID where a franchise was seeking new franchisees, sent out a Zoom call and shared a lot of very sensitive information about the franchise, things that it deemed to be trade secret information, with the folks who logged on to the Zoom call to learn about the franchise. Turns out a couple of those folks were not interested in becoming a franchisee at all. Instead, they used the information and went out and started their own business, and the company sued. And among other reasons that the company was unsuccessful was that the company did not follow either its own protocol or Zoom protocol for establishing a secure call. So it did not check, assure correct login. It did not have the security procedures in place. It didn't even ask who was on the call or if folks were with the people that had logged into the calls. And there are a variety of other ways that your trade secret information could be compromised by remote work policies. If someone's sharing a workspace with a roommate or a partner at home, if they routinely do work in a public place where information could be seen or observed, if there are not procedures in place for how trade secret information that's in paper form be destroyed when the individual is finished using it, or how and where it's kept in the remote work environment, those could all be things that could destroy the trade secret status of very important information. So it's very critical that your trade secret, that your remote work policies are updated to include trade secret protection strategies as well. And as I mentioned, it's just critically important that you act now. We do trade secret audits of these kinds of things, and it's just critically important that you really have things buttoned up so that if you are required to use trade secret theories to protect against a critical employee going to work for a competitor, that you are well armed to be able to do that. And with that, I think we have come to the conclusion of our prepared presentation, and we can take a few questions if we have them.
Yeah, Debbie, so it looks like there's one here maybe you can speak to. We have a question regarding if the proposed rule, FTC rule, has any exclusions such as where the non-compete was agreed upon in exchange for a long-term incentive plan.
Yeah, that's a question that we get a lot. There are some exclusions. There's an exclusion for when it's in connection with the sale of a business, for instance, but that appears that it will be tied to a percentage interest. Right now, the proposed rule says 25%, but the commentary suggests that could go as high as 50% or as low as 10%. So that would be an exclusion. I think it's much more unclear whether there could be a link to long-term incentive plans, but it would appear that at least initially that answer would be that those would be invalidated if it's just for an employee, even though it's part of a long-term incentive program. There was also some discourse in the commentary about whether there should be exceptions, for these, as you mentioned in the NLRB action, where employees are, an employer invests a great deal of money in training the employee. Questions about whether there should be exceptions or an ability to claw back, that kind of training dollars if the employee goes to work for a competitor. And I think largely those are still unanswered questions. And one thing I do hope is that whatever proposed rule comes down does provide a little more clarity, at least in the guidance and commentary on some of these important issues for employers.
All right, and another question we have is, we've mentioned that non-compete should not be a one and done, and what do we consider to be best practices? So as we touched on earlier in the presentation, there's several states that have various degrees of either bans on non-competes or restrictions. So really best practice would be to re-examine your non-competes and make sure, with an attorney that it does, what the language that you have is compliant with that state law, and also game plan maybe some different language you might want to have on deck should the FTC proposed rule go into effect and not be immediately stopped or challenged. So I think just reviewing overall to make sure you're compliant and also ready to go with alternative language would be the best practice there.
Yeah, I completely agree with that, Brittany. And one other point to add, I think, is, again, so many times folks are given these agreements when they start employment and they're never reevaluated. In addition to the changes in state laws and making sure you're compliant there, when an employee is long-term, their position likely changes, their responsibilities increase, and you may have a very narrow non-compete agreement that actually could be expanded based upon their increased responsibilities over the years. So I really advocate for, like job descriptions, an annual review of these to make sure you still have the most appropriate agreement for the individual.
Okay. It looks like we have another minute or two. We have several questions asking if you will get a copy of the presentation. The answer to that is yes. You will get the same slideshow presentation sent within a business day or two after. One more question, Debbie, if you would like to speak to if there are any exceptions to the proposed rule you can think of that might really come up in the M&A context.
Unsure exactly what the direction of that question is, and maybe we can follow up. But certainly, I think, again, when you're talking about if there are some employees who have an interest in the business as part of that acquisition, it looks like there would be an ability to make sure that there are restrictions in place with them. But I think as part of any M&A activity right now, due diligence should include a review of these kinds of agreements, certainly with an eye toward how that might change, what kind of vulnerability you may have with regard to key employees if the FTC rule goes into place, alternative ways to ensure that they remain with the company. So I think it certainly becomes part of the due diligence process as well. And if there's some more specifics on that, perhaps we can follow up with the individual who asked the question. But I do thank you all for attending our presentation today. As we mentioned earlier, and Brittany mentioned, we will be sending both the webinar and slides to everyone in about 2 business days. But thank you very much for attending today. If you have questions that we weren't able to address, please reach out to Brittany or I or your Thompson Hine attorney. If you're not currently a client of the firm, please contact us and we can discuss options to address your needs. But thank you all so much for attending today. We really appreciate it, and please enjoy the rest of your day.